Let's kick off with our regular feature, Focus on Health Law. This is a presentation of attorney Kenneth Haber of Boyd's, Maryland. The moderator on this set is attorney Ramesh Khurana of the Khurana Law Firm from Gaithersburg, Maryland. On this set, attorney Khurana has a bunch of questions for attorney Haber on common violations of Hipaa. Let's have a look.
Hello, welcome to the Capital Forum. This is Ramesh Khurana. I am an attorney at law and have my office in Gaithersburg, Maryland, and I practice mainly immigration laws. And I have a great pleasure to welcome Kenneth Haber, who is the former assistant U.S. attorney and the former senior attorney in the Office of Inspector General. And we are grateful to him that he has found time to come to the studios and answer our questions about Hipaa violations. In fact, we covered in one of the sessions part 1 about Hipaa violations. Now, this will be in continuation of the same session. Welcome, Kenneth.
Thank you. Thank you, Ramesh.
Thank you for coming, and we appreciate it.
My pleasure.
Now, while we want to talk about Hipaa violation part 2, can you please explain to us what is meant by a disclosure in order to avoid a serious threat to health or safety?
Yes.
This is a serious threat situation.
A serious threat.
Yeah.
We have those nowadays often, you know, in terms of people coming over with different type of health disorders, diseases, Ebola, and other type of things that are actually emergencies that the CBC and other healthcare institutions have to track down and try to quarantine and treat so that it doesn't get to be a mass epidemic.
You know, like you mentioned, even CBP, the U.S. Customs and Border Protection Force, now they are doing a great job in detection of Ebola at the port of entries when people come, and they have been fully trained like how to screen people. So they are really doing a great job. It's one of the federal agencies.
Yes, yes.
Yeah.
They check the passports, the visas, and everything. Right. They can see where they were exposed to, what countries they're exposed to.
Yes.
The fact of the matter is that when there are epidemics that are threatened, you know, it's a matter of saving lives, and that becomes a health emergency, and disclosures can be made that would otherwise not be made without permission in order to prevent, excuse me, to prevent those incidences becoming into epidemics. Tracking people down based upon where they were visiting overseas, and communications concerning it back and forth between law enforcement agencies and health agencies in order to track people down. This would all fall within the exemption, the disclosure to avert threats, healthcare or other threats. And it's vital to be able to have that flexibility, and the law recognizes that and provides for it. Otherwise, you'd have to go to John Smith to get his permission in order to put his name, you know, on a list for people to be trying to find. And if you knew where he was, you can get his permission maybe, but you know, without knowing where he is, you can't get his permission, but you need to put his name on the list so that the people can try to find him and make sure he's okay.
Right. Now, following on that note, my next question to you is, what are impermissible uses and disclosures?
Well, we know that disclosures to avert you know, healthcare threats, serious threats are permitted, but the fact of the matter is, shy of that, you know, you generally need people's permission to be able to disclose healthcare information, even their identity. You know, you need, but there are some others that are permitted, and disclosures can be made to law enforcement agencies with appropriate authorization, a subpoena, is one such authorization. Um,
You mean those are not HIPAA violations?
Not when you have the lawful
Right.
permission that is provided by the law, you know, and, there's administrative subpoenas, so, the Inspector General's office can obtain information, and on top of that, they have overall authority to review any departmental documentation or anything issued pursuant to the departmental programs in any event. So often they'll just give you a letter providing for it, saying it's pursuant to such and such official function. If somebody doesn't feel that's enough, then they can issue an administrative subpoena. They don't even have to go to a court. They just get a supervisor to authorize it, whoever has authority. And I know a little bit about the administrative subpoenas because I stole the subpoena from IRS and used it to make the HHSIG subpoena.
Oh, okay.
No need to reinvent the wheel.
Uh-huh.
When we were first starting up, we needed administrative
Right.
subpoenas. So they said, okay, can make administrative
Maybe at
subpoena.
that point of time, you were given the power to use the subpoena first time, and IRS had been using that kind of format since long.
That's right. That's
So,
right.
yeah.
The AIG's office had been given the authority to use the subpoena when it was the statute was enacted to make the AIG's office.
Okay, got it.
And different regulatory delegations, but we never had one. So we had a special agent or two had been with IRS, and one of the things good agents do is they always keep their form bank, just
Right,
like good
right.
attorneys. So one of them gave me a copy of the subpoena that IRS used, and we just used that, and we changed the statutory authorities, and so the IG's office had its subpoena, administrative subpoena. And we set up procedures for issuing them, and that's a lawful disclosure. It's permissible, and without it, it would be possibly impermissible, although a letter probably would do also. But you just can't give it for personal uses to somebody, even if they are in IG's office. It has to be for official purposes.
Okay. Now, my next question to you is, what is the concept of using the minimum necessary?
Minimum necessity is in terms of the information that's to be disclosed. And that's obviously a flexible concept, and I don't think too many judges are going to second guess people under most circumstances as far as minimum necessary disclosure, as long as it's for official purpose and kept within the concepts of the Privacy Act, of not making it public, not abusing it, when we're talking about official disclosure within agencies. But there still should be recordations of where to whom disclosures are made, and that should be kept within the HIPAA documentation. And people don't realize that, if you make a disclosure, a doctor probably doesn't realize that if he makes a disclosure to somebody, there should be a record of it. And whoever the disclosure is made to, like a business associate, they have to be obligated by, the privacy as well.
So the burden is so high under the HIPAA.
Well, it's just a matter of knowing how to use
and
it.
keeping records.
Keeping records.
Yeah.
And also, as I previously mentioned, a different program, I think, somebody can come in and say, this isn't right, this is not accurate. I want my medical record changed to reflect what's accurate. And if the doctor's office won't change it, then go to the Office of Civil Rights and try to get them to change it. Whether or not they would is administrative decision. But there is no enforcement by going to court directly under HIPAA. But, I've been thinking about this because of a case, and it seems to me that if a doctor's got incorrect information in their records, that one can sue them for false light if it's causing you damage, which is a concept within privacy, a civil concept under civil law, which is part and parcel of your privacy of the First Amendment.
Okay. Now, can you please also explain what do we mean by notice?
notice is various things under various circumstances, but it's quite often meaning you give notice to the patient that there has been a disclosure. That somebody came by and asked for it. Banks have privacy rules in terms of financial relationships that they have. And lots of times when there's an investigation going on, they'll get subpoenaed, and what they would do is get a court order to prevent them from giving that notice to their depositors. Now, I don't think there's anything equivalent to that in Hipaa where somebody's going to get a court order, although even though it's not in the law, I imagine that it could be, where you get a court order and order the holder of the information, the possessor of the information, to not disclose it if it's somehow going to be interfering with an appropriate law enforcement investigation.
Now, Ken, I know that certain safeguards are available. Now, can you please give examples of some of the appropriate safeguards?
Okay. That's a big one.
Yeah.
You've got information nowadays that's digital and that it's easily passed, it's portable, easily passed from one place to another. And the difficulty is how do you protect that? And one of the best ways is to have a good compliance program of people who know what they're doing in terms of compliance. And that means not only do you have somebody who knows what the law is, but somebody who knows what the IT aspect of privacy is, how to protect it that way so that there aren't breaches. And one of the things you need to do is make sure the staff knows what their obligations are, that they cannot go reading the information and then go, and this might be much more applicable in small towns where everyone knows everyone's business, that they know that they can't go and talk to it about anybody, because as soon as a secret's out to one person, it's out to everybody.
Right.
And staff needs to sign, if you have a good program, needs to sign some sort of document that they know that they're under an obligation to keep all patient information secret, and that they know that there's dire consequences if they disclose it, that they could be sued, that they're in violation of the law, and that the government can come after them for doing that, as well as their employer, and making each and every employee responsible for protecting that information, because the most breaches come from within.
Right.
That's where, we hear the big ones, where some hacker gets in, but quite often the breaches come from within.
Okay. Now, let me ask you one question. Let us say there is an administrative secretary in a doctor's office, and administrative secretary tells a neighbor that Mr. X came to our office today. Is it a Hipaa violation?
Yep.
I got the answer.
Yeah.
Thank you so much, Ken.
Thank you.
I appreciate you coming to our studios and answering our questions. Part 2 Hipaa violations. I found them very useful, and I'm sure our audience has been greatly benefited. And I welcome to our studios that you always find to come here and give your thoughts on some important issues. And hopefully we will invite you again, and I do hope you will come back again.
It would be my pleasure, and I'd just like to remind, all the different holders of medical information that they need, that it's their requirement to have a good compliance program, because if there's any breach and you don't, you really are up a creek without a paddle. So, it's bad enough that there is a breach, but if you don't have a good compliance program, then you're going to be negligent in holding that information.
Okay. Thank you so much.
Thank you.